Rule 128, General Provision, Section 1, Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Section 2, Scope. The rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. Section 3, Admissibility of evidence. Evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or these rules. Section 4, Relevancy collateral matters. Evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence in collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Rule 129, what need not be proved. Section 1, judicial notice when mandatory. A court shall take judicial notice without the introduction of evidence of the existence and territorial extent of states, their political history, forms of government, and symbols of nationality, law of nations, the Admiralty and Maritime Courts of the world and their seals, the political constitution and history of the Philippines, official acts of the legislative, executive, and judicial departments of the national governments of the Philippines, the laws of nature, the measure of time, and the geographical divisions. Section 2, judicial notice when discretionary. A court may take judicial notice on matters which are of public knowledge or are capable of unquestionable demonstration or ought to be known to judges because of their judicial functions. Section 3, judicial notice when hearing necessary. During the pre-trial or the trial, the court, motu proprio or upon motion, shall hear the parties on the propriety of taking judicial notice of any matters. Before judgment or on appeal, the court, motu proprio or upon motion, may take judicial notice of any matters and shall hear the parties thereon if such matter is decisive of a material in the case. Section 4, judicial admissions. An admission, oral or written, made by the party in the course of the proceedings in the same case does not require proof. The admission may be contradicted only by showing that it was made through palpable mistake and or that the imputed admission was not in fact made. Rule 130, Rules of Admissibility. Section 1, Object as Evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. Section 2, Documentary Evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Section 3, original document must be produced. Exceptions. When the subject of the inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost and destroyed, when the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. Letter B. When the original is in custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. Letter C. When the original consists of numerous accounts or other documents cannot be examined in court without great loss of time, and the facts sought to be established by them is only the general result of the whole. Letter D. When the original is a public record in the custody of a public officer, or it was recorded in a public office, and when the original is not closely related to a controlling issue.